very strong legal protections, the truth is slightly more nuanced. There are rare specific circumstances in which the United States government can revoke citizenship. This applies both to individuals born in the US and those who became naturalized citizens. Understanding these circumstances is important because they involve legal processes that most Americans are not aware of, and the consequences of losing citizenship can be permanent. American citizenship generally comes in three forms. One is being born in the United States, which grants you citizenship automatically under the Constitution. Another is being born abroad to US citizen parents, which also confers citizenship by descent. The third way is through naturalization, where an immigrant becomes a US citizen after fulfilling certain residency and legal requirements. While all citizens enjoy constitutional rights, the government handles these categories differently when it comes to revocation. Naturalized citizens face a higher degree of scrutiny because their citizenship is acquired through a legal process that can be reviewed and, in certain cases, reversed if new facts come to light. One of the most straightforward ways to lose US citizenship is through voluntary renunciation. This occurs when a person chooses to give up their citizenship intentionally. Renunciation must take place in person at a US embassy or consulate abroad. Individuals are required to sign an official oath acknowledging that they fully understand the consequences, pay a significant fee, and demonstrate that the decision is fully voluntary. Thousands of Americans living abroad have taken this step. Some do it to avoid US taxes, others for political or personal reasons, and some because they have committed fully to another country. Once renunciation is complete, it is permanent. The US passport is no longer valid, the right to vote is lost, federal benefits are no longer accessible, and returning to the United States requires applying for a visa like any other foreign national. Another way citizenship can be lost, which is much less well known, is through involuntary revocation, called denaturalization. This legal process occurs when the government determines that a naturalized citizen should never have been granted citizenship in the first place. Denaturalization is relatively rare, but it is legally sanctioned and occurs regularly in the United States. Fraud is the most common reason for denaturalization. If an individual lied or failed to disclose important information during the naturalization process, such as a criminal record, previous military service, political affiliations, or involvement in human rights violations, the government can take action to revoke citizenship. Time is not a limiting factor. Even decades after naturalization, citizenship can be challenged. Real-life cases demonstrate that denaturalization is not just theoretical. For example, some individuals who participated in war crimes abroad have had their US citizenship revoked once those activities were discovered. Similarly, former Nazi concentration camp personnel who lived in the United States for decades had their citizenship stripped and were deported. These are confirmed cases documented in federal court and demonstrate that citizenship, even after years of lawful residence, can be reviewed and revoked under specific conditions. Citizenship can also be questioned if a person associates with organizations that the US government deems hostile, including foreign governments with adversarial relationships with the United States or groups involved in terrorism or insurgency. If someone joins such a group within 5 years of naturalization, this can trigger a legal review. Even without participating in violent acts, affiliation with certain organizations can be sufficient to raise questions about whether the naturalization process involved fraud or misrepresentation. Serving in foreign militaries is another factor that can put citizenship at risk, particularly if the military is hostile to the United States. Serving as an officer or in a high-ranking position may be interpreted as swearing allegiance to another country. Similarly, accepting political office in a foreign government without US authorization can be seen as evidence of voluntary relinquishment of citizenship. The key consideration in these cases is intent. What actions demonstrate a willingness to abandon allegiance to the United States? Dual citizenship is generally allowed, but the intent behind obtaining another nationality matters. Simply holding citizenship in another country does not automatically revoke US citizenship. What matters is whether the person obtained the second citizenship with the specific intent of giving up their US citizenship. Swearing allegiance to another country, serving in its military, or taking political office can indicate such intent, which could lead to revocation under US law. Treason, rebellion, or attempts to violently overthrow the US government represent extreme circumstances in which citizenship can be revoked. These cases are rare, but are clearly defined in US law. Committing treason or acting as an agent of an enemy government, especially during wartime, can result in citizenship being stripped through federal prosecution. These cases are highly public, involve intense legal scrutiny, and may leave individuals stateless if citizenship is revoked. The Department of Justice actively investigates denaturalization cases through its civil division. They work closely with the Department of Homeland Security and Immigration and Customs Enforcement. Investigators review naturalization applications and may reopen old cases if new information emerges. Advanced databases and biometric tools help authorities detect past misrepresentations, undisclosed criminal activity, or suspicious affiliations. If irregularities are found, the government can file a case in federal court. Individuals have the right to defend themselves, present evidence, and challenge the case. Denaturalization is not automatic, it requires legal proof. Once finalized, the consequences are permanent. Losing citizenship has serious consequences. Denaturalized individuals lose their US passport, voting rights, and ability to remain in the United States. They do not revert to green card status, but instead become removable aliens subject to deportation. While birthright citizens, those born in the US, are generally protected under the 14th Amendment, even their citizenship can be challenged in rare situations involving fraudulent birth documentation, misrepresented parentage, or birth tourism schemes. Such cases are extremely difficult to pursue legally, but they are possible under specific circumstances. The common theme in all cases of citizenship revocation is intent and legality. Citizenship can only be taken away if authorities can prove that the individual voluntarily acted in a way that relinquished it or obtained it through deception. Legal standards are high. The government must demonstrate that the person acted knowingly and understood the consequences of their actions. If the legal threshold is met, the results are permanent. In summary, US citizenship is both a privilege and a right. It provides powerful legal protections and rights, but it also comes with responsibilities and vulnerabilities. Understanding the rules surrounding naturalization, renunciation, and denaturalization is essential for anyone holding or seeking U.S. citizenship. Whether you were born in the United States or became naturalized, knowing these laws and legal frameworks can help protect you and your family from unexpected legal challenges. Staying informed about immigration law, U.S. policies, and the rights associated with citizenship is vital because ignorance can have serious consequences. Citizenship is more than just holding a passport. It is a legal status that carries obligations, responsibilities, and privileges. Protecting it means understanding how it can be lost, voluntarily or involuntarily, and taking steps to ensure lifelong security and peace of mind.